Looks like we've hit 10 o'clock. So I'm Judge Edwards. We have Judge Orfinger, and we're pleased to have Judge Keith White, a circuit judge from the Ninth Circuit, sitting as an associate judge today. Typically what we do is we set a 5-minute time for rebuttal for the appellant. If you want something different from that, just let us know and we can make the adjustment. And we're here on our 10 o'clock case, which is Titusville Construction LLC versus the Wendy C. Butcher Revocable Living Trust. And it's case 19-3001. So with that, counsel for appellant, you may commence.
Thank you, Your Honor. May it please the court, Rick Asfar of Cottney Construction Law, appearing on behalf of Titusville Construction LLC, and I would like to keep the 5 minutes reserved for rebuttal. Thank you, Your Honors. Generally, we are asking the court to reverse the final judgment for one of two reasons, and this is a final judgment, awards roughly $20,000, $9,000 in compensatory, $11,000 in punitive damages. The first reason that we're seeking reversal and why we feel very strongly that reversal is appropriate is because there was a 22-month delay between the bench trial and the actual findings, the actual final judgment that was entered in this case. Plus, there were numerous indicators that there was something seriously amiss, including the judge. Apparently, this was something that was noted in the answer brief. The judge had said, hey, I might have overlooked some things in a pre-hearing telephone conference. Let's have a non-evidentiary hearing to make sure I didn't miss nothing. And the second reason we believe that that even if a new trial isn't warranted, this still needs to be reversed because the judgment itself is just replete with calculation errors and awards of things that are simply not justified under any view of the record. And so with that roadmap in mind, if the court has a preference as to which way I start first, I'd be happy to start with why I believe a new trial is appropriate.
It's your turn. You can go for it as you choose, but maybe Judge Orfinger has a thought.
Thank you.
Yeah, I had a question on the 22-month delay. I thought that after about 8 or 9 months, the judge convened a hearing or entered an order, I forget which, where he indicated his preliminary thoughts and then wanted some additional evidence taken on damages. So wasn't this really kind of a two-part process?
I appreciate that question, Your Honor, and you're absolutely correct. So the evidentiary hearing itself had ended on November 7th of 2017. What I'm going to refer to as the interim judgment was entered approximately 320 days later on September 26th of 2018. And that judgment had a number of items in it. The most material things that I can note for the court that was different was, number one, there was no actual figures in it. And number two, there was a recirculating pump that was added after the December 2018 non-evidentiary hearing. But whether it's a 22-month delay or a 10-month delay, this was still a very excessive delay.
Okay, thank you.
Thank you, Your Honor. So we've talked a little bit about the delay, and I don't think anybody is saying that the delay was justified under the circumstances, whether it was 10 months, 22 months. There was an interim non-evidentiary hearing for the sake of assisting the trial court with making evidentiary findings. We think that the substantial delay prong of the two-prong test is met. Also, we believe that there is a number of factors that indicate that this was seriously amiss. The first, we have to have one of the two key factors. The key factors being that there was an inconsistency between what the court said and what it did in its order. The second key factor, and the one that most of our focus is on, is that there's a finding that's unsupported by trial evidence. There's other factors, you fail to address certain issues, missing findings of fact, the order itself is confusing, perhaps there's an unequal treatment. Talked a little bit about the unreasonable delay. With respect to seriously amiss, the court said in and of itself, hey, we should have this second hearing because I might have missed some stuff and I want to make sure I didn't miss nothing. And when you look at for the inconsistency between what was said in the hearings and what was said, what was awarded, I got to focus the court's attention on the award for the HVAC unit, which was $1,928. And in that item, the court says, hey, I thought that was the difference between a 16 SEER unit in the contract and what was actually installed. And everybody was like, no, that is not the case. That is the difference between what was erroneously installed initially and what was replaced. But that was a cost that was never passed on to the owner. And the owner actually accepted this 15.2 SEER unit because it had a heat pump. And what was in the contract could not be configured with a heat pump. So she said, you know what, I'm going to accept this. And even though there was no evidence whatsoever that that was the difference between what was in the contract and not, and I have to note for the court that what was installed had an additional feature, a heat pump, which had a value. The court still said, you know what, I don't care, I'm just keeping this in. And so that indicates kind of an inconsistency between what was said and what the evidence was and what was ultimately awarded. There's a number of findings that were not supported. One was that $3,900 was fraudulently included in the lien, which was a payment made to Mr. Amos. The lien was executed in December of 15. The payment was made in January of 16. You can't fraudulently include an item in a lien if the payment had not yet been made. And we didn't even know about that because when the lawsuit was filed, it wasn't something that was specifically raised in the pleadings. The HVAC difference in price, that's something that we've already touched on a little bit. The court had said that a recirculating pump was not provided. This was one of those subsequent findings. This was not in the original.
Mr. Asmar?
Yes, Your Honor.
I'm sorry, going back to the payment to Amos Electric. But when you read the trial court's order and the statute, isn't it also a basis for a fraudulent lien if you include sums that are not owed pursuant to the direct contract, namely based on the trial court's finding, and I understand you may challenge that or not, but if the trial court found that the electrical system upgrade was not done, then aren't you including an amount for something that's not in accord with the direct contract? And wouldn't that provide the statutory basis for the judge to make the finding?
So what we're focusing on is the $4,470, which was awarded for that amount. And you'll see, Your Honor, that when I go through, I don't really stamp my foot very hard about that point. I do think that there was an electrical service that was of some value, whether when you look at Hurahan, the damage calculation is the difference between what was provided, which was 150 amp service to the pool house versus a 200, which was contracted for, plus a 400 amp panel. But the standard is whether or not it was a willful inclusion or a difference in numbers that was potentially the case. I appreciate the court's focus on that, but I'm trying to focus on some of the other items that I think were erroneously included, because we have this compensatory award that's given, but it's really a double count when you look at it, because you have $9,000 in compensatory awarded. The judge himself says there's an amount actually due in the punitive damage portion. And we not only get zero of what was actually due, but then we get it double counted as a further award on compensatories, which is just a lot of numbers going in the wrong direction. And so I think the court's point is well taken, that if that wasn't provided and if it was included, if there was no good reason, if there was that could be the basis for a finding, but just the mere fact that something is included in and of itself is insufficient to have a fraud finding. You have to have more. And in this case, I want to draw the court's attention to the fact that the decision on the service, that decision was not made by Titusville. That was made by a subcontractor after a conversation with the husband of the trust, who ultimately became a trustee and was in fact a party to this whole thing. And he was walking the property and saying, hey, this needs to be done, that needs to be done. At least he had a parent authority. And so to hang that up on my client when it was the sub who didn't do that work because he thought it was unnecessary, it's one of those things that I don't know if this goes back, if it gets found the same way. But going through these points, the HVAC unit clearly should not have been awarded. There's just no evidence there to say that 1920 was appropriate for that. The recirculating pump shouldn't have been awarded. That was something that was provided as a gratuity, and no good deed goes unpunished. He provided the pump, he had the plumber install it, and it was the connection that was made by the electrician, Mr. Amos, who the only payment on record is that $3,900 payment. There is no subsequent $100 check to him. But there's testimony from Ms. Berger that she paid, a butcher, that she paid another $100. The pre-wiring is as automatically being something she was entitled to reimbursement. And when you walk through the contracts, Your Honors, that's simply not the case. The electrical plans specifically say that whether the security pre-wire is going to be provided is per the owner and the contractor. The parties agreed that they wanted Tucker Electric to do that service. There was no request for a reimbursement. There was no providing of an invoice. There was nothing, literally, until we get to trial. It wasn't even mentioned in discovery. It wasn't mentioned in a pleading. It wasn't until we get to trial that for the first time that comes up. And it's one of those things that it just wasn't, there wasn't the substantial evidence there. I appreciate Ms. Butcher's testimony on that, but her testimony is insufficient to contradict what the plan says and what the contract says. And what the contract says is, we do whatever the plans say, and the plan says that the owner and the contractor can forego this, and there's no indication, no reference to a price adjustment if that happens. As somebody who recently built a house himself, I know that you don't get price adjustments if you decide to do something on your own. And so those are the 4 inconsistent findings of fact. Other serious indicators of an issue, there was the missed slander count in the initial final judgment. There's no addressing the wash agreement between whether or not the $1,800 for the carpet was going to get washed out because our client went above and beyond in installing cabinets, despite giving an $8,800 credit on that and incurring additional cost with respect to the tile that was installed. There's no addressing whether or not the pre-security was waived. That was an affirmative defense. There's no mention of the fact that the finding on punitive damages was by clear and convincing evidence. And again, you need more than just the numbers are off. That can happen in good faith. You need clear and convincing evidence that this was fraudulent, willful, bad, outrageous, and you need outrageous if you're going to award the full maximum punitive damages. This was a full maximum punitive damage award for something that the electrical subcontractor did, and it completely got hung up on the general contractor, which is especially troubling because there was testimony that the trial court refused to hear as to why that happened. And when you look at the judgment and the inconsistencies in the face of the judgment, you know, there's mention that the testimony of Human was discredited where it was in conflict, but I note for the court that his testimony on the wash agreement conflicted with Ms. Butcher's and it was accepted. So that's one very significant inconsistency right there. There were inconsistencies between the electricians and Ms. Butcher and Mr. Coleman as to whether or not the electricity worked. That is completely overlooked, and the trial court just decides to say, hey, you know what, I think even though these people aren't electricians, I think I'm going to go with them that this insufficiency is the reason that the wire trips. And even that, Mr. Coleman and Ms. Butcher disagree as to how frequently that happens. Mr. Coleman says it was once or twice. Ms. Butcher says it happens with some regularity. I've already talked about the HVAC, the amount due. The court acknowledges that there's some amount due and it's not backed out and it's not set off or awarded. There's a claim that Titusville didn't carry its burden of proof on the breach of contract, but the final judgment paragraphs 4 and 5 acknowledge that there was a contract. Paragraph 13 of the final judgments, both of them acknowledge that the house was completed. And though the court makes reference to breaches of contract, like the 400, 200 amp service not being in, none of these are deemed material. The court never finds that there's a material breach that would absolve the trust from not paying anything. And really they couldn't, because all of the professionals said, hey, this is a really nice house. It functions, it's good, people are living in it. And the court did acknowledge that there was an amount due, but it simply refused or declined to award that or set that off despite all of these things being present.
What is the consequence of the trial court finding the lien to be fraudulent? Does that just prevent enforcement of the lien, or does that prevent enforcement of the contract?
My understanding, Judge, is that only prevents enforcement of the lien. You can still have breach of contract, and I believe that there are some cases that are cited in the papers that point that out, where the lien might be lost, but there's still an award that goes to the contractor because they did the work. And this is a case where they did the work. They provided at least $140-something thousand, $145,000 a house. They got paid only $136,000 for it. Yet somehow there's a $9,000 compensatory award going the other way. So ultimately, you have a situation where the trust is getting $145,000 a house for roughly $130,000. And that's simply inequitable. It's against the substantial completion doctrine. It's just not right. And, you know, the court had some inconsistencies.
Mr. Aspar.
Yes.
But I believe you recognize that under the law, if there's a material breach of contract, that does in fact excuse the performance of the non-breaching party, right?
I would agree. However, there is no such finding in this case. There's nowhere in either final judgment where it says that this was a material breach. And frankly, Your Honors, I'd be hard pressed to see how it is. It's a beautiful house that works, that's occupied. They never changed, they never altered the electrical service. It's still, as of the date of trial, it was still exactly the way it always was. So how material could it be if somebody can live in it and occupy it and not change it? And so that's why I would respectfully submit that this isn't a material breach that would warranted, passing up all of the final almost $15,000 payment.
Well, Mr. Asfar, assuming for the sake of argument that reading the judgment in its entirety doesn't show that the judge did find a material breach, although maybe he didn't use the magic words material breach. Let's assume that that's not there, it doesn't rise to that level. What about the terms of the contract itself? Your client agreed he would not be paid that final payment until electrical service was complete. I understand you may challenge the judge's finding, but if the judge finds that didn't occur, setting aside some sort of unjust enrichment theory, under the terms of the contract, doesn't that excuse the homeowners from paying?
I appreciate that, Your Honor. And in this case, I don't believe it does, because I would submit, and I think the evidence is clear, that the electrical work is complete. There is electrical service at the house. It works. There was testimony from the building inspector who said, yes, the certificate of completion was provided, but it shouldn't have been until the electrical met the spec. However, when you look at the plan says that the spec could be adjusted, the electrical can be adjusted based on what the mechanical engineer, the contractor, sees. And I would submit that that is arguably what happened here. There is an electrical service at the property. Does it meet the spec? It does not. Is that a material breach? I would submit it's not. There is final electrical. The house is occupiable.
You're into your rebuttal time. Do you want to save the rest of that?
I will, with one note, which is that the Ms. Butcher did in fact pay the, pay the electrician. And with that, I will. Yeah.
All right, Counselor, you may proceed.
Good morning, judges. May it please the court, Allison Curry from Upchurch Bailey and Upchurch on behalf of the appellee, the Wendy C. Butcher Revocable Living Trust. And we're here today after having an extensive trial where the trial judge has heard testimony of witnesses, extensive evidence in the record, 8 pages of specific factual findings, and the appellant is here asking this court to reweigh those factual findings. And that clearly is not what needs to be done in this case. The trial judge in this case found that the principal, Mr. Human of Titusville Construction, was significantly less credible. They described him the way that he sent the final invoice. The trial judge described how he got an email from Ms. Butcher pointing out that the electrical was not finished. The 450 amp service or 400 amp service was never installed. He got the email within hours, had an inspection, got a certificate of completion, closed out the permits, sent her an angry email. The judge said there's no good faith dispute. There's not a minor mistake with the lien. He willfully filed that lien, including work that he knew he had not done, because Ms. Butcher had just pointed that out to him in an email. So we have clear findings that it was knowing and it was in bad faith. As to the issue of delay, or actually the one issue is, it's not whether the house is nice, whether the house is beautiful. It's whether the house was built according to the contract, the written contract, and the plans and specifications that were required. And it's also not up to Titusville Construction. Can't point to the subcontractor and say, well, I didn't comply with the contract because the subcontractor didn't do what he was supposed to do. So it's Mr. Human, it's Titusville Construction that's responsible. As to the delay, it's clear in the record. You can see the procedure we went through. The judge had the trial. He had the November 2017 trial. In September of 18, we get a final judgment. We had a hearing on damages. It got scheduled. It got rescheduled twice. We finally have the damages hearing and then an order entered. And I think it's a hard argument to say that there's some sort of, when the judge has made this significant factual findings, very specific, to say that it's now, there's some sort of irregularity. The
Evidence, Counselor, was there with regard to the air conditioner, the $1,900 to replace the ream that was definitely non-compliant with what apparently seemed to be a more acceptable, even though not this specified air conditioner. The evidence seemed to me that the $1,900 had been paid by the contractor, not by the homeowner. Is that correct?
No, Judge, I don't believe so. It was, there's testimony from Ms. Butcher in the record as to the payment for the AC, for the HVAC. And there, as today, there's still not an HVAC that complies with what the contract required.
What amount did she actually have to pay extra and actually pay for the different unit?
Well, I believe what the 1928 was what the court found to be the difference between the two. The difference in what she received versus what she was entitled to.
15.2 and the 16 SEER?
I believe so.
But Ms.
I
Curry,
thought that
guess-
was the difference between the ream and the other unit, but
The 1928. Well, the findings that the trial court made was it was the difference between what the contract required and what the contractor actually delivered. And there was testimony from Ms. Butcher and also from one of the subcontractors. And also the engineer, Ed Shinsky, he went through and he said it is a beautiful house, but there are a number of items that are not according to the contract, not built according to the contract.
I understand that. I understand there were other items. I just was curious about the air conditioner. That seemed to sort of stick out to me.
But
And if I could follow up on that, and Mr. Asfar sort of mentioned this in his argument, and that is the trial court did different calculations. And the analysis may be different, both legally and factually, depending upon whether we're looking at an affirmative claim by the contractor, a defense by the homeowner, or an affirmative claim by the homeowner. So my question is, Ms. Curry, is if I accept your client's arguments with respect to the judge's rulings on the judge's decisions adverse to the contractor on the affirmative claims, in favor of your client on the defenses, but where is the competent substantial evidence that would support an award of compensatory? So even if I agree, for the sake of this question, that the use of the 1928 could be appropriate in calculating punitive damages, how is it appropriate in computing compensatory damages when the measure of damages for breach of contract, which your client would bear the burden of presenting the evidence, would be a diminution in value in the AC as installed and the AC as set forth in the contract, or the cost to replace or repair or upgrade the AC as installed to make it as per contract?
I believe those are the same measurement, Judge. Under Grossman Holdings, the Florida Supreme Court case, the measure of damages is the reasonable cost of completion or the difference between what your contract called for and what was actually received.
Right. So my question is, where's the evidence? Because there's clearly evidence to support the 1928 figure, $1,928, but doesn't the evidence show, even viewed in the light most favorable to your client, assuming that would be an appropriate way to view it, that that was what the contractor paid to replace the erroneously installed ream system and put in the system that's there now?
And another issue related to this is the lien itself. There were 2 units included. He charged for 2 units, and not the lien itself, but in his final affidavit, he listed 2 AC units as being an amount due.
And again, that's why, for purposes of my question, I'm not talking about a calculation that may use 1928 to calculate punitive damages, but compensatory damages have to be compensatory damages, not as defined by the statute, but as, you know, the Grossman Holding case that you cited. And where's the evidence that the homeowners paid anything to convert what I'll call the 15.2 SEER unit to a 16 SEER unit? I don't believe that was ever done. And if you, maybe you can point me to somewhere in the record where that is, or someone, and I know there was expert testimony, but someone who testified that the 15.2 SEER unit is in value $1,928 less than the 16 SEER unit called for by the contract. I don't recall that testimony, but maybe I'm missing something. Is there something in the record that you could point me to?
As specifically on that, there was testimony about putting in one unit, removing another unit. There were some labor charges back and forth. And I think what the trial judge did was he took all the testimony, Ms. Butcher's testimony, the subcontractor, the engineer, and from that, all those different input of all those different numbers came up with the finding for the 19.
Counsel, it seems to me that East Coast Air and Heat invoice 6603 for the replacement 15.2 temp star unit, and the original ream had apparently cost $46.75. That's where the 1928 comes from. If you get 1928, that's fine. And as Judge White said, that may be useful for one thing, but unless the homeowner paid 1928, why is the homeowner entitled to 1928 as compensatory damages? That's our question.
Yeah, I mean, to be frank, I think what the trial judge did was he said, I'm going to find this as the difference between the 15 and the 16. And I think
based on what competent substantial evidence, I mean, you're talking about a 0.8 SEER. The one that they requested would have been a 16 SEER, and instead they got a 15.2 SEER with a heat pump. And I don't recall, and again, as Judge White asked, if you can point us to the testimony where somebody said the difference between the 16 SEER that she wanted and the 15.2 with the heat pump is that amount, that's fine. But we see the evidence as to where that number comes from, and that doesn't seem to be the basis.
Okay. And again, I believe it just goes back to the trial court and the fact that the appellant's asking this court to come in and reweigh and redo what the trial court has done.
You see a search for finding competent substantial evidence is the same thing as reweighing the evidence?
No, not at all. Not at all, Judge. But the trial court does come with a presumption of correctness, those findings under Tyson versus Edwards, under this court's decision. And the Zinger case that we've cited says that you're not to disturb those findings unless they're clearly erroneous and find that they're manifestly against the weight of the evidence. And I don't believe in this case there's anything in the record that meets that standard in Zinger. There must be a conflict between the findings at trial and the judgment that was entered in order for them to claim that there's some sort of, that the delay in this case was a problem. But again, there's the trial court's findings are extensive and are based on the testimony that's in the record.
In essence, by not having to pay, your client did not have to pay the final draw, correct?
Because the work was not completed. The engineer testified that.
Right, and then also got an award of $9,000 compensatory, is that correct?
That's correct.
So basically $23,000 in change plus the punitive damages, is that correct? In terms of not having to pay 14 plus getting an extra 9.
Well, but the 14 was not due because the 14 was not, the work hadn't been completed.
I understand, but I'm just saying, as counsel for appellant pointed out, essentially the defendant got a $23,000 plus or minus deduction in the cost of the house plus punitive damages as a result of the final judgment, correct?
I believe so, but again, the punitive damages are separate from that. But I think the breach of contract is what the court found she was entitled to based on what was not completed and what was not done per the contract for those amounts.
Ms. Curry, let me ask you, the trial judge in paragraph 36 of the judgment found that the actual amount due under the amended claim of lien was $3,700 and change. Did the contractor receive, or were they entitled to receive, any offset for the amount that was actually due?
Well, there was the amount that the homeowner was due is significantly more than that. It would have subsumed any set off that would have been there, but the trial court made that finding for the purpose of the calculating the punitive damages award, not that that was the reason, not that it was some calculation for an award to the contractor, because he found the contractor was not due that amount, but this, because he hadn't completed the work, but out of the amount in the lien is what the difference is, what that $3,000 figure comes from.
Did the contractor have an unjust enrichment claim?
He does not, Judge, not in this case. And there's another issue, the $14,000, that final draw, Ms. Butcher actually paid the electrician. The contractor didn't pay the electrician. So there's that amount also as well. But in this case, what the contractor did not do, clearly the amount that is due to the trust is clearly exceeds any set off that he would have been entitled to. But in this case, but just to address counsel's argument about the HVAC unit, and I've covered that the subcontractor is not the party that's here. The contractor can't claim that. The pre-wire, there's been some issues about that. That's clearly on the plans. The recirculating pump, there was a written agreement between the contractor and the homeowner concerning that recirculating pump, the $100 item that's in the record at 1201. There's clearly support for that as well. And I would just claim under Shaw versus Shaw, as far as Supreme Court, this judge had significant findings based on the varying demeanor and credibility of these witnesses, and even said in any dispute between the two that he would find Ms. Butcher to be credible and all the other witnesses in lieu of Mr. Human. So I don't think we can, at this point, Mr. Human, any of his testimony was not credible to the trial court, and I believe that presumption comes that it's correct at this point. But I don't believe there's any contradiction in the factual findings that would meet the test for the delay to be so serious. In the Carnicella case, there's not that sort of circumstance in this case where you can claim that 22 months is per se, and that was basically the argument, that 22 months per se is unreasonable. And in this case, the cases that were cited by Titusville, by the appellant, are based on an arbitration case.
Did the trial court fail to rule on your slander of title count?
I believe so. I believe trial counsel, I don't know, I believe they just didn't do that. I believe there was clearly slander of title. I believe there was evidence in the record to show that she had to go bond off this lien. She had her closing, she testified that she had her closing for her financing, for her permanent financing was postponed, canceled, because this lien came up in the title search prior to her closing. And she testified extensively about the effect that had and how she had to go and redo her loan and post a cash bond to get rid of the lien. So it's clearly there, and I don't know why they didn't.
I don't think appellant's begging the court to now add that back in, but I think he was using that as evidence of the fact that the 22-month delay between trial and the final judgment, that's evidence that there were errors and mistakes made and inconsistencies along the way, rather than everything's fine, don't worry, there's no big deal about 2 years between a trial and a final judgment.
But the inconsistency did not damage my client. The inconsistency it helped the appellant in this case. So I think it's hard.
He's well aware of that, I'm sure.
That they've been damaged by the trial court failing to make that one ruling.
Anything further? All right, we'll go back to do you have anything further, ma'am?
No, Judge.
Okay, We'll go back then to the appellant.
If I might just have a moment to get my thoughts together before the clock starts running,
Fine.
I appreciate that.
We'll give you a 30-second timeout.
Thank you. Thank you, Your Honors. Initially, I just want to make clear, we're not seeking to rewrite factual findings. We're seeking one of two things, either a new trial or to correct the numerous errors in the calculations. I think the court has seized on the fact that the Hvac is a ruling that is simply not supported by substantial competent evidence. I think the court has also found that has seized on the fact that the slander of title was not addressed in that initial final judgment. The judge had to be reminded to put that in. And in the final judgment actually ruled against the homeowner. So that was adjudicated. It was just adjudicated 22 months later against the homeowner. So I think those show that there's something seriously amiss, along with the court's comments of, hey, I think I might have missed some stuff here. And that's why we think that there should be a new trial. Shaw versus Shaw, the Tyson case, those are not cases that had delay. I agree. Typically, you have a presumption of correctness, but still, if there's a lack of substantial competent evidence, you got to reverse. And that's exactly what happened in the Zinger case, which counsel has cited to. There was a lack of substantial competent evidence. It did have to get reversed. And because there was a cold record, it was reversed for a new trial in that case. Judge Orfinger, I think, did an excellent job of seizing on the set-off issue. There's an amount due. There should have been a set-off. I appreciate Appellee's contention that the set-off would have been washed out. I think once you go through the numbers and you look at this with the detail that our brief does, you see that that's simply not the case. But just because it's going to get washed out doesn't mean you don't apply it. And in this case, the set-off was just, it was simply never applied. And I think, yes, sir. Yes, Your Honor.
With respect to the issue of the 1928, if you look at the judge's ruling, both the order as well as the statements in the hearing transcript, can't we conclude that rather than there being something amiss in that he didn't recall the evidence or misunderstood the evidence, he actually made an erroneous legal conclusion? I mean, couldn't you read his statements as saying, I'm determining that the amount of diminution in value, the lesser value of words to that effect, was 1928, which is a proper statement of the law, although, as you've indicated, I'm not necessarily convinced that the evidence supports that.
I appreciate that, Your Honor. And I do want to note very briefly before I focus on your question that Hurahan is the damages case. And that was a case where the house was not built to spec. It was facing the wrong way. And it was still the diminution in value was the appropriate amount of damages because it would have been waste to tear the house down and bring it back up. Setting that point aside, I think that the court's point is when you look at the comments, there was a colloquy between my partner, Mr. Oblo, Brian Oblo, and the judge, where the judge says, wait a minute. I thought the evidence was that the 16 SEER without a heat pump was worth 1928 more than the 15.2 with a heat pump, which is better with respect to the heat pump. And Mr. Oblo was like, no, that's simply not the case. And even trial counsel for the appellee was like, Judge, no, it's not necessarily the case, but you got to give us what we can get based on what's before it. And with that, I see my time is up. Respectfully request the reversal, either to back out all the items as indicated in our brief or for a new trial. 22 months, there's obviously some issues here. We thank the court for its time.
All right. Thank you, counsel. We'll be in recess.
Thank you, judges.
Thank you, everyone.